I can't.
Thank you so much. So I will at some point be speaking on GDPR, but what I love about Zoom now is that it tells you, of course, that you are now subject to being recorded and that you should know this so that you can agree or leave. So thank you all so much. That is for another day. But today I'm going to talk to you about legals. What legals? Now, this could very well be a dull subject. And I know that everybody often shies away from legal contracts and that type of thing because it's not the most exciting part of a business, particularly when you're setting up. What's often so much more exciting is using things like Canva and the design tools that you can use and doing exciting things like branding and engaging photographers for your website and copy and finding new clients. So that's all really important and it's very, very exciting. What's great is that that continues to be exciting. But as we continue through business, what we often find is that we've forgotten what we never even thought about at the very beginning in the inception of our business, and that is the legals. So that's what I'm going to talk to you about today. So without further ado, let's get cracking. You all know me now. I'm Erika Moralez Perez. So I am a corporate and commercial lawyer by trade. And what that means is that I deal with all business legal matters. So that might be helping you to incorporate a limited company, or it might be regulating your relationship between yourself and a business partner, identifying who and how you can issue shares to people. And the reason I know about this is because I've spent 7 odd years now practicing as a business lawyer myself. So I qualified into regional private practice where I was for 5 years, and then I have subsequently been working on my own, which is very exciting because I get to work with amazing businesses like yourselves and I get to choose who I want to work with, which is also amazing. But prior to that, I was in business myself for 10 years and I worked for big corporates like Microsoft, Samsung, Hewlett Packard, and that was absolutely fantastic. It gave me an incredible background about business because for Microsoft, for example, I managed £100 million worth of business. So it was really key for me in my legal training to understand how a business operates and the considerations of an entrepreneur and a business person. I'm sure you've all experienced that lawyers don't necessarily always see it from your point of view as a business person. They often see it from just a lawyer's point of view, which can be very black and white and very unworkable. So I like to say that I operate in the grey. Now, I want to be clear about grey being very much above board, but what I mean by grey is that there's typically a solution for all parties involved in any legal problem. And if we focus on the solution, not the problem, we can always find a way around it that's agreeable to all parties. So that's how I work. These days, I work with very corporate clients, so large organizations, as well as small businesses, and essentially everything in between. So I work with startups, ensuring that they have all of the documents in place that they need, and I sell that by way of bundles, for example, right up to offering interim head of legal solutions as well for corporate clients. So it's very exciting, and there's never a dull day in my world, so which is lovely and exactly how I like it. So the things that we're going to cover today are what are legals, why you should have them, why spending a little bit of money on them will save you thousands of pounds in the future, and then hopefully we'll have a bit of time for a Q&A as well. If you do think of something you'd like to ask, please write it down. The beauty of these smaller groups is that you can ask me questions, and it's like having your personal lawyer for a bit of time to answer those questions that you might have. So please don't hold back. There are no stupid questions, and I always like to answer as many of them as I can. So what are legals? Well, we've already identified that they can be very boring and very dull, but what the dictionary definition of legals is that they are of, relating to, or concerned with the law. So legal papers. So what do we all immediately do when we think of legals? We go, I don't want to think about them any further. Thanks for the definition. But what does it really mean in reality? I've put a few documents up here just as a food for thought, and I could have gone on and on and on and on, because there are many legal documents that you might need throughout the course of your businesses. But some of the very basic things that you should have are terms of business, confidentiality agreements. I mentioned GDPR very briefly at the outset of this presentation. You should all have a privacy notice. I assume, and perhaps you can give me a bit of a show of hands, but are all of you online? Do you all have a website? Raise your hand if you do. So everybody has a website, so we should all have a privacy notice on our website. And what that privacy notice should say is what data we're collecting about the people that we're working with, what we're doing with that data, how we're using it, where we store it, and how long we're storing it for. So there are some basic and fundamental things in every agreement that should be present, and that depends on the agreement. If you're dealing with third-party processors, and this might be prevalent for somebody like Marie-Louise. Marie-Louise, you may or may not use third parties to help you with some design work. When you're doing branding, you might outsource some of that work. And if you're doing that, you might need data processing agreements. I do a lot of work with both music industry clients and branding agencies, and often they're using third-party providers, so they should absolutely have agreements with those providers. If you're a photographer, you might want to ensure that you have a license agreement in place. You might want to be really clear in your terms of business with your clients that if you're taking photographs for your clients, that you own the intellectual property, you own the copyright to those photographs. What can they do with them? If any of us are parents on this in this group today, we've probably all bought those terrible photos that they take of our children at school. We all buy them because we know we have to. We don't want to be that parent. I certainly don't want to be that parent that hasn't bought the photo when everyone's asking at the school gates. Did you buy the photo of the boys? No, I thought it was hideous, and everybody gasps in horror. So I buy it. It's 40 quid or something ridiculous, and you get one copy. They print it for you. They won't even give you a digital license. And they're really clear about that. When you click on their website, this is what you'll get, not much, for your 47 quid. We should all be being that frank about what we're offering. If you're a consultant, I often work as a consultant for my clients. You need to tell your clients what they're getting. If you don't, there's lots of ambiguity on how long you might be working for them for, what's your day rate or your hourly rate, when are you going to charge them, how are you going to bill them, when should they pay you, is it 30-day net, is it 60 days net? Some of the clients I work with offer you 90-day nets. You know, you could be being paid 4 months down the line. The point with this and with all of these agreements is that it makes things really, really clear, and that's why you need them. I have put up here shareholder agreement, and it's really important, and there's always a very clear point about a shareholders agreement. If you have a limited company and you have other shareholders in your business, you should be regulating that relationship with a shareholder agreement. This is not something that is automatic that comes when you set up your business on Companies House. It is a private document between you and the other shareholders. But what it does mean is that if it's properly drafted by a solicitor who should not charge you the earth for it, you will be able to do the things that you want to do with your business, including, if the time comes, parting company with that other shareholder. I have had the very sad job of having to wind up a multi-million-pound turnover business because the founders and 2 shareholders who owned 50% each of the company fell out irrevocably, and they were unable to sort out their differences. She wanted to buy him out. He said, over my dead body. It was going to cost them £160,000 in litigation to fight each other for this business. So what they had to do was wind the business up. They were literally achieving their commercial goals and their commercial dreams and doing amazing things with this business. And because of one silly scrap, they had to wind that business up. So that's what having these agreements, and that's what legals really means. Writing things down, making things really, really clear so that you don't have issues that you then cannot resolve. Now, there is some statistics that suggest that on average, a small business will spend approximately £6,000 a year on legal fees because they didn't have legals in place to begin with. So the cost of fixing a problem that could have been easily fixed with a 1 or 2 page document costs the business on average £6,000 a year. I know for my part, that's not money I want to be spending. And that's not to mention the stress and the sleepless nights that comes alongside the grief that that causes you as a business person, as well as taking you as a very important resource to your business away from fee earning activities because you're having to put effort and time into resolving these issues. So what does legals really mean? What does legals really mean? It means a long list of agreements that may or may not be applicable to your business, but you have to take advice and decipher what you need and when you need it. And out of all of that long list, which of course is a very much truncated list, it may be that you only need 1 or 2 of them. So please don't be alarmed. But those one or two agreements will save you lots and lots of time, effort, energy, and stress in the future. And because the list seems endless, is the reason that usually legals are at the very, very end of everybody's to-do list, but they needn't be. So 5 really good reasons to have them, and we have already addressed many of them, but essentially it protects your business. It protects you as a business owner. It sets the expectation really clearly on what you're getting. It specifies what you'll be providing and for how much. And it's true whether it's your terms of business, a shareholders agreement, as we've already discussed, or a commercial lease with regards to a property. I guarantee none of you would buy a property, commercial or residential, without making sure a solicitor had reviewed it for you and having that contractually documented on a piece of paper. So, number 2, own your content. So if you're here, your content is probably really important to you. It certainly is for me. So what is your client allowed to do with the content that you produce or provide them with? What happens with the imagery, your design? Know upfront, as I've suggested with photographs, know upfront what you're giving your clients and make sure they know too. All too often, suppliers and customers aren't clear on what they're offering, and it ends in tears for all involved. And that's often what could have been an amazing business relationship. So help to avoid mismatched expectations by setting those expectations really clearly. So term and termination. When do you start working for a client? When do you stop? Is it perpetual? Do you want the ability to get out of it? What might occur that means that that relationship comes to an end? So how long will that agreement last? And how do you get out of it when you're done? Specifying what happens if one party doesn't deliver, and that includes your customer because there's always obligations on them as well, is really important. So you have to specify what happens if one party doesn't deliver on the bargain. It limits liability, number 4, a really key point, probably the most contended point of any commercial contracts are the limits or not limits on liability. But great legals being in place help minimize the potential for disputes because we'd be really clear up front on what your limitations are going to be and what you're going to provide in terms of liability to your client. The great thing is as well is that if your opposition, your client or your supplier is taking great legal advice, they're going to see your terms and conditions with your limitation on liability, and they're going to see you as really credible, and they're not going to want to take you to court anyway because they know they're going to have no chance of winning. So it helps you all round. And number 5, it helps you comply with the law. So certain law and regulations, such as GDPR, for example, in certain jurisdictions mean that you have to communicate certain matters to your customer in a contract in writing before a contract is formed, such as e-commerce and distance selling regulations in the UK, for example. By having killer written terms, your lawyer will have taken care of all of that on your behalf, meaning less sleepless nights for you. So ultimately, it comes down to money. Putting great legals in place will make sure that you comply with the law, and it will make sure that you are really clear on your relationship with your client or your supplier. But essentially, what you should also know is that oral contracts are valid. So in English law, we allow oral contracts, but what you don't want to be doing is having to seek to rely on them when you have a problem, which is what many of us do. Oh, but he said this. Oh, but she said that. Oh, I'm sure that's what we agreed. Or the reverse, you do have some documentation in place, but they're only emails, and you're scrolling through your Gmail accounts looking for something that you agreed 17.5 years ago. So make it really clear, put it in writing. Spending the money up front is always better than spending the money afterwards to fix the problem. Both my mum and my grandma always used to say prevention is better than cure, and there's never a truer word spoken when it comes to contracts. Always the prevention and not the cure. So why do they save you money? Well, they reduce the cost of sale. They reduce your negotiation time. We keep it nice and simple, nice and clear so everybody understands it. Time and cost savings and energy. It means that you can focus on your fee earning work and your revenue generating work. It saves time on your management and your legal fees because, again, a litigator is much more expensive than a commercial lawyer drafting a contract. Litigation in itself is hugely costly. And it also limits the potential costs for non-fulfillment. Now, many of us would have experienced the force majeure clauses that we've all hoped to invoke over the course of this pandemic. But that's not a statutory right. So it's worth noting that if something like that is not in your contract, it's not written down and agreed between the parties, then you cannot rely on it. So you might feel in that situation a little bit like that poor polar bear stuck on a piece of ice in a very cold ocean. So write it down, you won't have that. But the images are there really for a bit of fun, although it does relate directly to this. So it will save you thousands in the future because it will save you from lack of productivity due to sleepless nights. It will save you from meltdowns and feeling like the polar bear, and it will save you both time and £1,000 in therapy to deal with the stress of litigation. So your top tips for when thinking about them. I won't go through this in detail in the interest of time, and I do accept that this is quite a busy slide, but please feel free to photograph it. Essentially, really think about what you need for your business. Draw up a list of the key commercial terms, so when you want to get paid, how much, how you get out of the contract, what you're delivering. Imagine your most awkward customer. We've all had them, let's be honest. We've all had that customer where we have that gut feeling when we engage them and we think, I really shouldn't be agreeing to work with you, and then we do it anyway, and true to form, your gut's nearly always right, and they cause you no end of grief. Think about that customer. What went wrong? What could you have done differently? What didn't you write down that you could have? Just think really clearly about what will make doing your job easier, and think about some of the difficult conversations that you might have had to have. If they're in writing in your terms and conditions, chances are it would make it much easier for you moving forward, and it means you don't have to have the difficult conversations because they're already written down for you. So think about all of these things. When in doubt, please always seek help. Ask advice from a mentor, a professional, or a fellow business owner. Most of the people that I work with and come across are always willing to talk to you. I personally always have free of charge conversations with people at the outset. So I'm not one of those lawyers that charges for every minute you speak to them. So please do ask, because often peers and people around you will have the answers and will be able to advise you. So please don't forget, legals are those documents that we all want to ignore. Don't ignore them. Invest in having well-drafted documents. Please don't download things from the internet. Often they're very well-drafted terms and conditions or documents in general, some of the things we've covered, but one size never fits all. There are things in those documents that you may not be applicable to your business. So please don't cobble them together or download them from the internet. Remember copyright when you're downloading from the internet. The written word as well as images are copyright protected, which means that the author has the rights to those words and those images. If you take them off of the internet, chances are you are breaching somebody else's intellectual property rights. So please consider these things when you're doing that. Keep them fair and balanced. Gone are the days where lawyers draft contracts that are all one-sided. All that happens is you spend thousands in negotiating them. So keep them simple, keep them balanced. Ensure they're as short as they can be and make them applicable and commensurate with the size of what you're doing. Your standard terms and conditions should not be 57 pages long. I drafted yesterday a set of terms and conditions for swimming pool installers. Obviously, they're, as you would expect, they're quite high value products. They come with installation services. They were probably 15, 16 pages long, but they were fair. They dealt with the consumer rights. They dealt with the cancellation. And by the time we've formatted them beautifully, they'll probably be 3 or 4 pages long. But ensure they're applicable to what you're doing. Train your teams on why these are important and how to use them. I can't stress this enough. I work with small businesses and large businesses. Even the small businesses, one of them, for example, installs beautifully handmade bespoke windows. Their team members have to understand that because of consumer regulations and consumers' rights to cancel orders, it is imperative that they have their documents in place and their contracts signed. So communicate this with your teams, teach them how and why and where. Once they're bought in, they will do your work for you and make sure they're handing out the right documents at the right times. And draft using plain English and not legalese. I personally don't speak Latin. I didn't train in law in Latin. I have no idea what most Latin phrases means. I have to Google them. So chances are so does everybody else. So just keep it really simple so everybody can understand. Thank you very much for listening. I hope it wasn't too dry. Do you have any questions for me? Debbie?
Do you do so I've got contracts, various things that I've got. Do you do like a review service of people's existing things, and whether, because obviously a lot of mine was set up a long time ago, so I've got marketing contracts, staff contracts, contracts to work with freelancers. What you know, do you do like a service where you'll look at all of that and just review everything? Brilliant. Okay.
Thank you so much for asking. Yes, I do. So I offer a fixed fee legal health check service. Brilliant. Where I'll review everything you have, and I'll produce a simple one-page document for you to say exactly what you need and why you need it, and where I can recommend that you either shrink your contractual suite of documents, etc. So I will make all the recommendations for you.
Brilliant. Thank you. Anyone else? They're all a bit stunned into silence. Oh, look, Emma's asking, and Maria.
Just following up really on what Debbie said about reviewing contracts, a bit like wills, because wills are a contract. Do you recommend every so many years contracts should be reviewed, or is it just when they get really old or change of circumstances?
So really the latter, I would say, Emma. I don't believe in spending money where it's not necessary. And even if I review your contracts, if I determine that you don't need to change anything, I would tell you that, because I couldn't sleep at night and take your money to revise your contracts when they don't need them. So personally, really only when there are big circumstance changes, or the way in which you do your business, or your order process, or there are big changes in the law. So many contracts had to be revised for the purposes of GDPR in 2018. But other than that, then you shouldn't really need to be revising them on a regular basis.
Okay. Yeah, I was thinking just more legislation with changes. Sometimes people aren't aware of smaller changes in legislation. So
yeah, absolutely.
Thank you.
Thank you. Marie-Louise, you had a question.
It was more of a comment, really. I was attending a talk about GDPR yesterday, and so it got me really, you kind of touched on it a little bit in today's session, but the big takeaway that I think is very valid for everyone listening to all this like legal stuff and all things is actually breaking down the tasks. You know, like yes, all these things have got big ramifications if it goes horribly wrong. But as small businesses, we've got so much on our plate. It's about sort of breaking down those tasks. So I'm a great believer when you kind of have things repeated or like hear it again. I'm like, right, I've got to sort my legal stuff out. So like I'm getting that. But what I'm going to do is do a bit of a brainstorm of the kind of gaps in my business and kind of you know, put like how important it is, or, you know, prioritize it, and so that I can break down, but definitely revisiting my terms and conditions, which I did have professionally drawn up, but my circumstances have probably changed significantly since those have done. And it's really got me thinking about how I onboard clients and like training and stuff like that. So really, really great presentation. Thank you.
Thank you very much. I think that's a really valuable comment as well, Marie-Louise. Thank you. Definitely break it down, think about what you need to prioritise and budget for it. GDPR is probably more costly than not having your terms and conditions in some cases, because if you process high profile and very sensitive data, for example, Catherine, I see you joined us. Catherine probably in her line of work processes sensitive personal data and special categories because of the type of service that she offers, and therefore that's probably more high risk than having terms and conditions. So think about that when you're prioritizing as well. But it's a really, really great point, Marie-Louise. Thank you very much. Very pragmatic way to look at it as well. Vince.
Yeah, hi. That's really interesting. Really well explained as well. I want to say that.
Thank you.
So in a nice, simple terms, which I think, you know, if I understood it, I'm sure everyone else did. So, which is great. So if someone, say for example, you've got, you know, I'll give you an example. You've got someone who's, I don't know, selling wood flooring or something. They've got contact details on their website, so you can input name, address, and they'll get back to you. They should have a data protection policy, shouldn't they, as well? Because you've got data going through the ether or through the internet. Is that right?
Yes, absolutely. So if you're in business, you have clients, then chances are you're processing personal data, and you should have a privacy notice that sets out how you process that data.
Perfect. Yeah, because there's been quite a few high profile breaches, hasn't there, as well, of data getting out into that obviously links in with cyber security as well.
Yes, absolutely. I actually I had a team of my lawyers in acting for an international bank back in 2018. There were 6 of us, and we were there for 9 months sorting out their data protection and how they complied with GDPR.
Wow.
And the reality, the sad reality, is that they had a series of breaches in one way or another because there were holes in their practices, which was partly the reason we were there. But it cost them an awful lot of money, to the tune of $8 million at the time a year, just in fines for breaches. But there are, it has to be regulated. You know, similarly, I have an estate agent client, and they were reported to the ICO because they had a chap who was organising a Macmillan coffee morning. So it was done with the best intentions, but he authorised the IT providers to essentially do a mail shot to 15,000 customers, old and new, many of which had opted out of marketing communications. And even though it was for a Macmillan coffee morning and it was done with best intentions, out of 15,000 contacts, 2 complained. One of them just happened to work for the ICO.
Oh dear.
So, you know, it's worthwhile. They were fine. They weren't fined because they had processes adapted for them on their GDPR processes and procedures and policies. So, so they were compliant anyway. So they, you know, they got off with a slapped wrist. But what they hadn't done is make sure that that particular individual and individuals at that level were not authorized to instruct the IT providers to do such massive things. So it's just about thinking really clearly about what you're doing and how, etc.
Brilliant. Thank you, Erika. Has anyone got any last questions before we go into the breakout rooms? No. Okay, thank you. That was really interesting, Erika. I know sometimes people think that their subject is really dry, and of course you deal with it like all the time. But sometimes there's a lot of things you think, yeah, actually, yes, I need that. Or so I think you've given quite a lot of us something to think about.
Thank you.
What I'm going to do is I'm going to put everybody into the breakout rooms. So we can be in 3 rooms of 4. And then we'll discuss what contracts that we've got in place now with our business, and or what do we think that we need after listening to Erika's information. If I'll just allocate some room leaders, and then what we'll do is report back like we usually do at the end of the sorts of things that come up. So room 1, Catherine, will you be able to, are you happy to do that? Room 2, Debbie, I think you can do, I think she'll be a good room leader. Room 3, Jennifer, are you okay to be room leader for room 3? So we're discussing what contracts we've got in place now and what do we now think that we need. And so we'll put you in the room for 20 minutes and then it will let you know that your time is up and bring you back to the main room. So I'll see you on the other side. Going to pop you into your rooms now.